All right. Again, ma'am, you're Veronica Randall.
Yes, Shannon.
And Mr. Vasquez, will your client waive the formal reading?
This case starts with pure courtroom tension, because this isn't just about theft anymore. It's about history catching up. Veronica Randall is back before the judge after missing a previous plea setting, and that one missed appearance forced the entire legal process to restart from zero. In court, that's not a small mistake. That's a giant red flag. And now, every prior conviction is about to matter. When prosecutors start talking about enhancements, that usually means one thing. The sentence just got a whole lot heavier.
Of the indictment in each of the cases.
Yes, sure.
Judge, may we proceed on paragraphs 1, 2, and 3? We'd kind of gone round and round on this at one point, but especially in looking at the criminal history and the PSI, I feel confident that with paragraphs 1, 2, and 3, it will make it a sequence for second degree.
Well, I have to have two. We gotta have two regular thefts. So 2 and 3 are misdemeanors. That's what makes it the state jail. And so then I would need,
Oh, I'm sorry. I didn't realize they were bullet points. It's been a minute. So could we go on the April 10th?
we went through 1 through 6 last time.
Okay.
Can we just do that
Sure,
again?
yeah.
Because we had already figured that out, that covers it.
Yes, ma'am. Thank you.
Okay.
Thank you, Your Honor.
All right. So the state has elected to proceed on counts 1 through 6. And Ms. Randall, I know that we've gone through all of this before, but because I rejected that plea when you didn't show up, that we have to do all of this again like it didn't happen, okay?
I was in the hospital.
Well, I'll get all of that information. I just want you to understand why we're
Yes.
having to go through all of it again, ask the
That's
same
right.
questions. And so she will waive the formal reading of the indictment in each case, correct?
Yes, Your Honor.
So in clause number 25 DCCR 0246, you're charged with the state jail felony offense of theft of property with previous convictions from November 21st of 2024. The indictment alleges further that you were convicted of theft April 4th of 1984. After that was final April 11th of 1985. And then after those were final April 10th of 1989. And then November 12th of 1991. 1, 2, 3, 4. And then October 10th of 1994. And those are the two regular felonies. Okay. And how do you plea? Make sure. District court, district court, district court. Okay, that gets us to the it's okay. Second.
And my notes were just wrong. Sorry, my apologies. I had 1, 2, and 3 plus the sequence. I just read it back to you wrong.
Gotcha. Okay. And so how do you plead to that charge, ma'am? And are those prior convictions true? Did you enter your plea of guilty and true just now freely and voluntarily? And because you actually did what they've charged you with? Give me just a second to make that notation. It'll take just a second for me to get this pulled up right also. Right, and cause number 25 DCCR 0247. You're also charged.
This is the legal gut punch. Enhancement statutes turn what might have been a lower level offense into something that carries real prison time. So even if the new charge seems minor on paper, the sentence absolutely isn't. Veronica realizes in real time that her old theft convictions are now helping push these new cases into second-degree felony territory. That's the moment defendants hate most. The second they realize the past is writing the future. Does this feel like justice or punishment stacking? Let me know what you think.
Charged with the state jail felony offense of theft of property with previous convictions. This is from November 16th of 2024. It alleges those same prior offenses that I read from the prior indictment. And how do you plead to this charge?
I'm not understanding. You charging me from them four that you just read out in the two I'm here for, what I'm
So-
in jail for now?
So you've got two new,
Right,
Theft.
that I'm in jail
right,
now.
but you have, because of your prior offenses,
Right. I
in
didn't
each
get
of the-
time.
right.
This
it
is the
enhan-
legal gut punch. Enhancement statutes turn what might have been a lower level offense into something that carries real prison time. So even if the new charge seems minor on paper, the sentence absolutely isn't. Does this feel like justice or punishment stacking? Let me know what you think.
It enhances these now to a second-degree felony.
Okay, it was a third degree when I was here in October.
No, it was a second because I have the indictments that I wrote on specifically when we went through all of that. Because
Yes.
they were regular felonies,
Mhm.
it makes it a second degree.
Okay.
Okay, so to the charge of theft in 25 DCCR 0247, are you guilty or not guilty?
I'm guilty.
And then for those prior convictions, are they true or not true?
They true.
So did you enter, in this case, your plea of guilty and true freely and voluntarily?
Yes.
And because you did what they charged you with?
Right.
In each of these cases, I have the documents on the tablet that have your signature on them that the state's marked as exhibit number 1. Did you go over these with Mr. Vasquez again?
Yes.
And there's the cliffhanger. No sentence today, just a reset. That might sound like a delay. But in reality, this is a judge gathering ammunition before the final decision. The updated probation report could help her or completely sink her. Judges don't just sentence charges. They sentence patterns, behavior, and credibility. The next hearing is where everything becomes real. Will she walk away with mercy or 6 years of regret? That answer is coming next.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
So as long as I give you 6 years or less, you can't change your mind and appeal. Do you understand?
Yes.
Okay. And you're a U.S. citizen, correct?
Yes.
State tenders number 1 in each case?
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Ms. Randall is not competent?
No, Your Honor.
Okay, I just went through. Is there going to be a dismissal? There's 3 cases
Well, there's going to be a dismissal since.
in 1686.
Yes.
Okay. All right, Ms. Randall, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty, but I'm going to reset your case so that the
And here's the
probation.
cliffhanger. No sentence today, just a reset. This pause can work for or against the defendant depending on what that updated report shows. The judge is gathering context, not just charges. And when we come back, that's when everything becomes real.
The probation department can do an updated report. That'll just give me, primarily, I need more information about where you've been since we entered that plea. Obviously, we have all the information already from prior to that. And so what I'll do is just do a normal reset, which is about 4 weeks instead of the 6 or 7 for the PSI, since they don't have to do all of that information. Then we'll come back for sentencing. Obviously, anything that you think is important for me to know, Mr. Vasquez will be out there to visit with you, get that information to him. He'll present it to me on your behalf when we come back. Okay. All right, you can go back with the bailiff.